Whoa!
I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh,
that's enough. I don't want to hear another word.
Okay, I'd like to also
another one. I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
All right, everyone. Today's courtroom case features a sovereign citizen defendant facing an incredibly serious situation, up to 30 years in prison. Despite the severity of the charges, he chooses not to hire an attorney. Instead, he decides to represent himself, believing he can handle the case on his own. As the hearing gets underway, it quickly becomes clear that he's relying on many of the familiar sovereign citizen arguments that courts have consistently rejected for years. The judge, however, wastes no time bringing the discussion back to established law and courtroom procedure. What follows is a tense exchange that shows just how difficult it can be when legal theories collide with the reality of the justice system. As you watch, ask yourself this: if someone is facing decades behind bars, is representing yourself really the right decision? Let's get into today's hearing.
All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir. I'm going to represent myself.
All right. You're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, counsel, suspend or revoke, third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes.
As the hearing continues, the seriousness of the situation becomes impossible to ignore. The defendant remains focused on sovereign citizen arguments, even after the judge makes it clear just how much is at stake. Rather than addressing the criminal charges directly, he continues relying on legal theories that have repeatedly been rejected in courts across the United States. The judge patiently explains that the courtroom must apply existing law, not personal interpretations or alternative legal beliefs. The focus remains on the evidence, the charges, and the legal process established by statute. When someone is facing a potential sentence measured in decades, every decision inside the courtroom carries enormous consequences. That's why experienced legal representation is often considered one of the most important parts of a criminal defense. What do you think? Was the defendant standing by his beliefs, or was he making a decision that could seriously damage his own case?
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I end up plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir. I
You have copies for the state?
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
As the discussion continues, the defendant begins citing legal terminology, including references to the United States Code annotated, apparently believing those references support his position. While the United States Code annotated is a legitimate legal reference used by attorneys and judges, simply mentioning legal terms doesn't automatically strengthen a legal argument. Courts look at how the law actually applies to the facts of a case, not whether someone can recite legal language. The defendant also raises several theories commonly associated with the sovereign citizen movement, including arguments that courts have consistently rejected over many years. Throughout the hearing, the judge continues steering the conversation back toward established legal principles and the issues directly related to the criminal charges. Do you believe the defendant genuinely trusted these legal arguments, or was he hoping they would create enough confusion to influence the proceedings?
He's already entered a not guilty plea. We'll set this for pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
By this point, the judge appears increasingly concerned about how the defendant is handling his own defense. Rather than allowing the hearing to drift further away from the actual legal issues, the judge takes steps to restore order and encourages the defendant to receive proper legal assistance before moving forward. From the court's perspective, criminal proceedings are governed by established rules, evidence, and legal precedent, not personal legal theories. When someone is facing the possibility of a lengthy prison sentence, understanding those rules becomes critically important. Some viewers may feel the judge was firm but fair, while others might believe the defendant should have been given more freedom to present his arguments. It's a question that often sparks strong opinions whenever sovereign citizen cases appear in court. Now we'd like to hear from you. Do you think the judge handled the situation appropriately? Would you have made the same decision if you were presiding over this hearing? Share your thoughts in the comments below. If you enjoyed this courtroom breakdown, be sure to leave a like, subscribe to Courtroom Chronicles, and turn on notifications so you never miss another real courtroom case. Thanks for watching, and we'll see you in the next courtroom story.